Hi, I'm Emily and I am here with Maya Murphy's attorney, H. Daniel Murphy. Attorney Murphy practices at Maya Murphy's law offices in both New York and Connecticut. My question today for Attorney Murphy is, in Connecticut, is legal custody the same thing as child custody?
In Connecticut, whether the parties are in a divorce or some kind of proceeding to determine the custody of a minor child, even if the parties are unmarried, and in Connecticut, a minor child is defined as a child under the age of 18. The Superior Court here has the authority to issue orders with respect to both legal custody and physical custody of the child. And these are two separate, two distinct types of custody. Physical custody addresses a child's residence. So that's where the child lives on a day-to-day basis. In joint or shared physical custody arrangements, the child will spend time with both parents according to a schedule that's either predetermined and agreed upon by the parties or decided by a court after hearing all the evidence. And that doesn't necessarily mean half the time or 50-50, even though it may be called joint physical custody or shared physical custody. In fact, we see all different kinds of arrangements that may be appropriate for particular families, depending on work schedules, depending on how far away the parties live from one another, how much travel time would be for the child to go back and forth, and any other special circumstances related to the child. The garden variety non-custodial parent visitation schedule is becoming more the exception than the rule, and that is the midweek dinner and every other weekend type of visitation arrangement. That's a little less typical as time goes on. Courts have become and plans have become a little more creative, often more equal in terms of parenting time between two different households. And the parenting plans have been crafted in ways to minimize disruption for the child, and sometimes in cases to minimize unnecessary contact between former spouses, so that drop-offs are smoother and things along those lines. So these arrangements, whether agreed upon by the parties or whether they're ordered by a judge after a hearing, they all have to be in the best interest of the minor children. So either a court has to make that specific legal finding that these arrangements or whatever the order is in the best interest of the children, or the parties have to certify that fact at judgment by their own testimony. There are very rare circumstances where one party might be the sole physical custodian of a minor child, but it can happen. And in some circumstances, one parent may be named a primary physical custodian. Legal custody, as opposed to physical custody, is different. That relates to parents' rights, obligations, and responsibilities to make major decisions for a minor child. So major decisions are not what to have for lunch or what to wear in the morning to school or what sports to play after school. Major decisions are those decisions related to education, religion, non-emergency medical care, and other major life decisions which could impact the health, safety, and well-being of children. So typically speaking, these are usually joint decisions. Typically legal custody, whether again after a trial or by agreement, is almost always joint legal custody. There are circumstances where sole legal custody can be awarded, but in other words, it takes quite a bit for a court to award one party or the other sole or primary legal decision-making authority when it comes to major decisions for a minor child. Although there are cases where one party may be awarded final decision-making authority in the event of a dispute or an impasse between the parents, although even that is relatively rare. The best interest of the children is the benchmark for both legal and physical custody. And how do we determine best interest? Well, best interests are determined based on a whole host of factors within the law, which I won't cover completely here. And they're very varied, but some of them are a child's developmental needs, the parents' abilities to understand the needs of the children, the child's preferences and the parents' preferences regarding schedules for the child, the past and present relationship between the child and each parent, as well as other family members in the house, and each parent's willingness to comply with court orders. A court may also consider the stability and the residence of the parents or any history of neglect or abuse or domestic violence within the house, as well as the health of the parties and the parents, both mentally and physically. The child custody matters I just talked about, especially child custody trial work where there is not an agreement between the parties, that can be very complex and very fact-specific. And because a court has extremely broad discretion in how to fashion child custody orders, You really are best served by speaking with an experienced family law trial attorney about the particulars of your case.
Attorney Murphy is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Murphy at hdmurphy@mayalaw.com, and please visit mayalaw.com for more information.